Oh, if you should look up the series called Stingray. That came out, we were just, yay. Oh, yeah. I remember the first V.
So what's her name? Elizabeth.
He's not on Zoom. Oh, yeah. Hi. How are you guys doing? Oh, the attorney thinks I'm speaking to him.
Oh.
Hey. Hi. I am. Oh, no, but those were two jurors who are going to be on the jury trial. Well, welcome. Do you guys have any questions about anything?
Waiting for the ride to pick me up.
Oh, awesome. Well, I can tell you what's happening. What's going to happen right now is the deputies went to go bring out some inmates and they're going to enter into a plea bargain agreement. And then there are some attorneys who need to speak to the state about different things. So defense, prosecutors, if you all want to tell them what you all do, and that's probation there, Bianca. So if you all have any questions, you can ask them.
It's right there.
I have Yes. Yes, something went wrong with the computer, so I had to do a completely new Zoom link.
Just, may I ask if you're going to take Salgado Salinas last on our preliminary matters? Are you going to take the pleas first?
Well, there's a plea. As soon as they're ready to go, we'll go on that plea.
Okay.
But as soon as they bring your client out, any motions that you all can't agree on, just approach and let me know and we'll take them up.
Okay, cool.
Sure.
Thank you. I just need to let my firm know if I can squeeze in these meetings, but I've already told them no.
Okay,
Yeah. Thank you.
you're welcome. It just takes a little bit of time for them to bring them from downstairs. And are you ready on your case?
Yes, Your Honor. May I approach?
Yes. And it is Christopher Gill?
Christopher Gill, Your Honor.
All right, where is he?
He is present, Your Honor.
All right.
Christopher, stand up.
All right, Mr. Gill, if you'll come forward. Hello.
Hello.
Hi, you need to make sure you're on time next time, okay?
Yeah, I know my ride was a little late.
This is what I always tell people when they have rides. You know, your ride doesn't have to be here on time, but you do, okay?
Sorry.
That's okay. Just make sure you're on time next time, okay?
Of course.
All right, so where are we on discovery?
Judge, state's made an offer. We haven't been made aware of any discovery that's outstanding.
That's correct, Your Honor. And that the state did make an offer today.
Okay.
And then I also believe, Mr. Chaffetz, you may be here on someone else's behalf.
Yes, I'm here for Mr. Lara, Your Honor. Guillermo Lara is actually the attorney of record.
Okay. All right, and then How old are you, sir?
I'm 20.
28?
Yes.
All right. So I'm gonna set this for a plea deadline date. Ms. Ferguson, if you can recall this in 3 weeks, please. All right, so we're gonna be back on October 8th. On that date, you need to let the court know whether or not you have reached an agreement. If you have not, then the next step is gonna be setting you for a jury trial. All right, do you have any questions about anything? All right, thank you for dressing appropriately. Once you sign the reset form, you're excused. All right,
Gentlemen,
thank
good
you.
afternoon.
Thank you. Have a good one.
Thanks.
How's it going?
It's good. It's good. I'm officing over with Joseph Holscher.
Ah, okay.
Yeah, so it's going well.
Yeah, I was wondering, I'm like, where is he? I haven't seen him in a long time.
Yeah, I'm officing with Joseph Holscher, just good doing solo, but it's been good. It's been fun.
You'll get trials with him, right?
Oh man, we were in a nasty one in Bracketville yesterday.
Oh, okay, where is that located?
It's about 45 minutes from Eagle Pass.
Mm,
So just on the border, we're just a little down.
okay.
Yeah.
What were you guys trying?
It was an assault case, but it was one of the clerks at the court's spouses who was assaulted allegedly. So it ended up in a mistrial.
Okay.
Halfway because it turned out everybody knew about it. Like it slowly came out that like, oh yeah, I remember. Like even if they didn't at the very beginning, when things would come out, they'd go, oh,
Oh,
I remember that. Yeah.
Ah,
It was a fun one though. It was
yeah.
it was fun with Joe. I don't know if it would have been
Yes.
without. Yes.
All right, can I see the file on Jonathan Ramirez, please? Jonathan Ramirez. Oh, have a seat. We're waiting for your attorney. All right. And you were late.
What's your name?
Johnny Trevino?
Think that's Mr. Acevedo, client, Judge?
All right. Just have a seat. Your attorney is zooming in. And could I see the file on Johnny Trevino? Yes. No, that one was Giovanni. And I also need the file on Marcus Berry. You know what? I think Marcus Berry, I want to say, I think Judge Angelini may still have that one. All right, thank you. So that's been done.
Who was the first spelling asked for, Judge?
Oh, no problem. The other one was Jonathan Trevino. Or Johnny Trevino.
Oh, sorry, thank you. Thank you so much.
Thank you.
You too.
All right, so then on Wilfred Salinas. Where's the attorney? Oh, just have a seat, sir. Do y'all have your motions?
I believe we e-filed them,
Do you have any copies?
no, and I apologize for that.
No problem.
I drove in from another county, so,
No, we'll get it. If you could do me a
Okay.
favor, there's a clerk in back.
okay,
If you'll give them this cause number and let them know that we're going to be hearing motions
Okay.
on your case, and then they'll print them out.
great, thank you so much.
All right, you're welcome. Yes. All right, send me his email and I'll just forward it to him. What's his email?
Judge, I can't hear you. I'm sorry.
Is there a reason you were late today?
I was asked to come at 1:30.
All right, so
March
you didn't
30th.
know you were supposed to be here at 9?
No,
Okay. Okay. Then why isn't it on the docket for 1:30? But that's okay. All right. So where are we with discovery?
Judge, I conferred yesterday with ADA Escobar, and he had reviewed
notes from the previous ADA that I had conferred with Mr. Edelman, and he had sent out a request, our previous setting for videos that were, but he didn't notice that they'd received any new videos, so we're still waiting for the co-ban on this.
I don't know.
Of the,
So how long have you been waiting on Coban though?
it had been another month, Your Honor.
So does Coban actually exist?
It should exist.
Judge, this is Daniel Escobar for the state of Texas.
Oh, we're not on the record.
Okay.
Yeah.
As far as I can tell, I mean, it wasn't uploaded in the initial batch. There is other co-ban that is connected to this case, so that's the thing, is we just don't know if it's out there.
All right, so we don't know if there's Coban in existence. Is that what you're saying?
So we have co-ban for other officers that are involved, but there are specific officers that the defense was asking us to look for, and that's who we looked up.
So the Coban that you know about has already been uploaded.
Yes, sir.
And there are how many officers defense where you think there should be Coban?
There would be the arresting officer's vehicle and maybe one other one, Judge.
So arresting officer, Coban. And what other officer?
I have to go back and double check which officer you're on. I can get that to them. I'll email it to them today.
All right, so he's saying one Coban video is the arresting officer. And then he says there's another officer, he'll have to email you that.
Judge, we're gonna check right now on the SB 111 form to see if it actually marks a check mark. To say, give us a few minutes, we might be able to check that.
All right, thank you. All right, state is gonna look, just give them a moment.
Thank you.
And if you'll just step back, they're gonna look for that and then I'll call you right back up, okay? And Bashan, are you all ready on Tawana Adams?
Yes, sir.
All right, Tawana Adams?
We're gonna paperwork done.
Ah, okay, all right, thank you.
Yes. There's two co-ban videos, but we're not gonna do it. I don't know if that's the two. What's the three of us? There might be that. Yeah. Good enough. Yeah. Okay.
Judge, we have an answer.
All right. Mr. Trevino, if you'll come back up. Mr. Acevedo? And you're on mute.
I'm on there.
They have an answer for us.
Thank you, Judge.
Yes, state?
Judge, we have SB 111 form for this case, and it states that the co-ban associated with the actual, I guess, the day of arrest or the day of confrontation with the suspect, there's no code ban. And then also on Detective Moreno and Detective Garza, the code ban was not functioning. So any code bans associated with right now on Verific may be a later on, arrest or a warrant or something like that. But as far as we can tell, there's no code ban associated with the case.
All right, they're stating there's no co-ban associated with the case. So, Mr. Acevedo, what I'm gonna do is I'm gonna give you a final discovery setting date of 30 days, and that will be the last date for discovery.
And Judge,
Yes,
he
sir.
the SB 111 form, it should be on Verific or on his e-discovery.
And they say the SB 11 form should be on Veripic.
Yes, Your Honor, we went over that last setting. I'm aware.
All right, so Ms. Ferguson, I need a 30-day reset on Trevino, please. All right, so we'll be back on October 22nd. Thank you for dressing appropriately for court. You always do, though.
Yes,
So
sir.
Ms. Ferguson is going to give you a reset form and then you'll be excused.
Thank you.
Judge, and I had advised him to be there at 1:30. I apologize.
No problem.
Thank you. Yeah,
Thank
yeah,
you.
yeah, I appreciate you accommodating this.
All right, you're welcome.
Have a good day.
All right, Norma, Rochelle Acevedo is on Zoom. Hey, Rochelle.
Hi, Judge.
Hi, did you receive an email from me?
I did.
All right, that was the email actually for Alberto.
Okay, I saw him on and I was like, okay, maybe it was a mistake because you had me very concerned over here. I was like, there's nothing on my calendar.
You're usually on time, so it would have been fine.
Okay, well, thank you, Judge. I had just happened to see it.
All right, thank you. Have a good one.
You too. Thank you.
All right, are you all ready on Mr. Salinas? Thank you. All right, court is calling 2022 CR 2397 State of Texas versus Wilfredo Salgado Salinas. Can I have parties announced for the record for the state?
Daniel Escobar for the state.
Stephanie Collins for the defense.
And are you Mr. Salinas?
See,
Yes.
All right, we have an interpreter with us. If you can raise your right hand for me, please. Do you solemnly swear or affirm that you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand if you'll state your name for the record.
Arlene Abrams, license number 2081.
All right, so the first thing, my understanding is that he is requesting a jury trial. Is that correct?
Judge, before we reach that matter, I would like to ask the court to ensure that Mr. Salinas is desiring us to represent him. I know this was a question before, but before we proceed to jury trial, I think I need to put it on the record again if he wants us to represent him or not.
Oh, well, what I can tell everyone, this is an old case. I know that your firm was wanting to withdraw, and that motion was filed and the court denied it. And if he wants another attorney and does not want you to represent him, then he needs to have an attorney who's prepared for trial tomorrow, because this specific case will be going to trial tomorrow.
Judge, he has been trying to fire us for 2 months.
Mhm.
And we did not attempt to withdraw on our own request. We attempted to withdraw because he asked us to, and he's been asking the court to appoint him an attorney since July 25th.
No, he has not.
Those motions are in the file.
No, he has not been asking for this court to appoint him an attorney. And if my understanding is, one, you have not been the attorney who's been on this case. There's been another attorney from your firm. And where is that attorney? Because
Judge,
that's the
he's
attorney.
resigned.
No, that attorney needs to be here because he's listed as his attorney.
Anthony Wilson, or is that who you're speaking of?
No,
Judge?
I'm speaking
Carlos
of,
Ramirez?
yes, where is
Okay.
he?
I'm not sure. I think he is down taking care of other business.
He needs to come up here and take care of this business.
Okay, but Judge, I did see in Odyssey that there's been some pro se motions filed requesting an appointed attorney.
Let me just explain to everybody how pro se motions work. When somebody has retained counsel, their pretrial motions are not heard by the court.
Of
Their
course,
pretrial motions are only heard if they are pro se. He is not pro se. And Carlos Ramirez, who has been here, needs to be here. He knew that this was here,
sure.
so I do not understand why he's not present.
Okay, but the issue that we need to determine is if he, just for the sake of trial, and I understand, Judge, that you're gonna call this case tomorrow regardless, but for his sake and ours, I need to put on the record if he is wanting us to represent him at trial.
All right, so what I'm telling you is the person to be asked those questions and to put it on the record is Carlos Ramirez, not you.
Well, I am also listed as attorney of record, Judge.
Well, I'll have them check to see if that's the case. Ms. Ferguson, can you look and see if she's listed as an attorney of record? Or is it just their firm?
Judge, I see Carlos Ramirez, Stephanie Collins, Anthony Wilson, all listed as his,
And are you Stephanie?
Yes.
All right, ask your questions.
Mr. Salinas Salgado, before this goes on, Judge, I would also object to this being broadcast on YouTube in the event that potential jurors are watching this right now, knowing that they're gonna be called to this court tomorrow.
Mhm.
I think that would be prejudicial, Judge.
All right, your objection is overruled. Do you have questions for him?
And I would object to the overrulement for the record. Mr. Salinas.
Just a moment. So this is how things work. You make your objections, I make a ruling. There is no, I object to the court's ruling. The court's ruling is the court's ruling. And if you're intending to preserve error, how you preserve error is you make a request, I make a ruling. That's your error. It's preserved. Preserving your error is not if I overrule an objection or I sustain an objection and you say, well, I'm objecting to your overruling or sustaining an objection. Legally, that's not how things work. So your objection to the broadcast is overruled. Now, here's my question. Is he going, if he were to be found guilty, is he going to the court for punishment or is he going to the jury for punishment?
We have filed a motion for jury, but I still need to determine if he wants us to represent him or not.
All right, so this is what I need you to do. I need you to listen to my questions, answer my questions, and we will go in the order that I'm giving you. So, Mr. Salinas, do you understand this process? Have they explained to you about jury trial? Well, let me strike that question. Don't answer that question. Let me explain to you. In this court, since you've been here, this is the process for this court. First thing that happens is I make sure that defense attorneys have all of the discovery. What is discovery? Discovery is items or evidence or proposed evidence about your case. So if there's a video that's about your case, the defense is entitled to have that. And I make sure that they have that. And if it's something that they say they don't have, or something that they think they should have, and maybe the state has and hasn't turned it over to them, I'll make sure that they have that. So in your case, your attorney has said they have all of the discovery. So that means that all of the evidence that you're entitled to, they have that. Your attorney, Mr. Ramirez, has said that's the case. Then the next thing I do is I tell the state in this court that you have to tender an offer. That offer will be given to your attorney. That attorney will go over that offer with you. And then there's something you don't understand about the offer, then you're to ask your counsel. Do you understand?
See.
Okay.
Yes.
So yes or no, has an offer been tendered to you in this case?
No.
All right, so this is what we're gonna do. I'm gonna have you sit down. The state will let this defense attorney know, because I know this defense attorney hasn't been here. It's been Carlos Ramirez. The state will let them know what the offer is, and then your attorney, who's here today, will let you know what the state's offer is. Then you will let me know whether or not you're accepting the state's offer or whether or not you wish to go to jury trial. Do you understand?
See.
Yes.
All right. If you do not reach an agreement, this will be going to jury trial. And what that means is a jury will be in the hallway at 10 o'clock. And then we will start jury selection. But the first step, the state is going to give the attorney here what their offer is to you. And then you will come back and let me know whether or not you're accepting that offer. Do you understand?
Yes, okay.
Okay, thank you. We're off the record. How do you say okay in Spanish?
Okay.
Okay, all right. See, usually, oh, no, it's fine.
Está bien, okay, yeah.
See, in French, it's d'accord. So I always thought there was some way to say it.
Acuerdo también, that's a good,
Okay,
there's so
that's-
many ways to say it.
All right, but you know what? I like saying Spanish, okay?
Okay.
So when people ask me if I speak Spanish, I can say,
Okay.
yes, I do, okay. All right, so have a seat
Tome asiento.
and state if you'll make sure she has the offer.
Okay.
All right. So Sharon Cardenas. Hello. Hi. All right, defense. Thank you for coming back. So, where are we on discovery? Okay. And was an offer tendered?
Today.
And counsel, I know you said you're going to be on vacation.
Yes, starting tomorrow.
All right, so when will you be back?
I will be back, October 1st.
All right. Norma, can you recall this in 30 days? All right, we'll do October 22nd. All right, is there anything else?
No, Your Honor.
All right, so what will happen is you'll be back on October 20.
I'm sorry, I have
Yes.
another vacation I'm going on with my mother-in-law.
Well, you should enjoy as many vacations as you can.
Well, she's turning 90, so.
Oh, that is awesome. Tell her I said happy birth
Yeah.
month. All right, so when do you want to come back?
Probably come back the week after that.
All right, Norma, can you put that the week after? All right, we'll be back on October 28th. Do you have any questions? All right, we'll see you then, okay? All right, who's here on Tawana Turner? Oh, could I have a file stamp for a plea, please?
Yes, sure.
Thank you.
I promise I will get it. to you.
No problem.
Yes.
Just give me 1 second. Let me just put this, Odyssey can be slow sometime. All right, court is calling 2024 CR, I'm sorry, I gave you the docket sheet for that, for this. Thank you. All right, court is calling 2024 CR 009363W, State versus Tawana Turner. Can I have parties announced for the record for the state?
And you asked for the
Defense?
Carrillo from Ms. Turner.
And are you Ms. Turner? All right, you're gonna need to keep your voice up so the court reporter can hear, okay?
Yes, ma'am.
All right, counsel, have you received all of the discovery?
Yes, Your Honor.
And did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Turner, did you review the document entitled Application for Deferred Adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the document entitled Waiver of Indictment, Reading of Information and Rights under Article 1.051 and 26.03 of the Code of Criminal Procedure with your attorney?
Yes, ma'am.
Did you understand it and sign it in the appropriate place?
Yes, ma'am.
Did you understand you have a right to have a grand jury hear the facts in this case
Yes,
and make a decision on whether or not to hold you over for a jury trial? Did you understand?
yes, ma'am.
Did you understand that your attorney has certain rights, namely 2 days from the presentation of the information and 10 days from the presentation of the information to prepare for trial?
Yes, ma'am.
Did you understand by entering this plea, you were waiving those rights?
Yes, ma'am.
And did you intend to give up or waive those rights and enter into a plea in this case?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Did you review the information with your attorney and did you understand it?
Yes, ma'am.
And state, are you proceeding on the information as presented?
Yes, Judge, it should be for possession less than a gram.
All right. Ms. Turner, did you review the document entitled Court Admonishments with your attorney?
Yes, ma'am.
Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with possession of a controlled substance, penalty group 1, less than 1 gram?
Yes.
That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up
Yes.
to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
My opinion, she is competent, Your Honor.
Ms. Turner, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney and did you understand it?
Yes, ma'am.
According to the plea, there's a $1,000 fine. State recommends you receive deferred adjudication. This will run concurrent with 2017 CR 6992. They will take into consideration 2024 PF 030353, and there's to be a drug court evaluation. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your deferred adjudication be for a term of 3 years. There be a TAP evaluation and 150 hours of community service restitution. Did you understand that was recommendation from the state and the court does not have to follow that recommendation?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
State offer states exhibit 1 and all attachments.
No objection, Your Honor.
All right, did you review the document entitled waiver and consent to stipulation of testimony and stipulations with your attorney?
Yes, ma'am.
Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. And for the record, are you the person listed in the police report as Tawana L. Amin Adams?
Yes, ma'am.
All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you applied for deferred adjudication. Are we proceeding with sentencing in this case?
Yes, Your Honor.
All right, so before we proceed with sentencing in this case, let's take up the motion to revoke. Are we still going to be going forward on the motion to revoke or no?
No, Your Honor, the state was gonna file a motion to withdraw, just so that it could be termed unsat and so that the probation can be continued on here.
All right, any objection with regards to the motion to revoke?
No, Judge, I do want to make the court aware that, case actually expired August the 21st, 2024. So a motion to withdraw and then term unsat, would be fine with probation, Judge, if that's what the state wants to do. We did, just for your information, Judge, in February, completed a TAP evaluation, and the TAP evaluation came back with a recommendation of dual diagnosis outpatient treatment, along with monthly urinalysis and sober support meetings.
Okay. All right, then we will proceed with sentencing in this case. So when's the last time you had employment?
June the 11th, because we got stopped on the 12th on my daughter's graduation. So June the 11th was my last day working. I was at Church's Chicken located on San Pedro and Bass Road.
All right, and who is James?
Rector,
Yes, to you.
my son,
All right, and who is Jocelyn Martinez?
my daughter-in-law,
All right, and how old is James Rector?
31.
All right, it appears that you all are not setting good examples for each other based upon this police report. So it appears that everybody's been using, is that correct?
Everybody been using.
Yes, I mean, the vehicle, when it was pulled over, they said there was a smell of marijuana.
Yes.
And then according to this, you had drugs in your bra.
Yes,
That's an issue. And that's a problem. So is your son on any type of probation?
no,
Do you have any grandchildren?
11,
All right. Do you have, and your biological children, how old are they? What are their ages?
36, 34, 29, 19, and 31.
So if you were released, who would you be living with?
My 34-year-old, she's here.
All right. And who's your 34-year-old?
Jonetta Henderson, same one that's always here.
Okay.
She's in yellow.
All right. So when's the last time, June 12th, the 2024, is that the last time you used or no?
I haven't used. I've been clean.
Okay.
Yes.
So when did you start using?
I have it.
No, I mean, at some point in time in your life, you used drugs. So when did you start? How old were you?
18.
And what drugs have you used in the past?
There was marijuana. Oh, in the past, marijuana, crack cocaine, cocaine, and heroin.
And then the meth that was in this case, had you ever used meth before?
No, ma'am.
But you had it in your bra?
Mm-hmm.
Okay. And mental health issues, have you had any diagnosis?
Yes.
All right, what's your diagnosis been?
ADHD, bipolar 1, and PTSD.
Is there anything else I should know?
No, ma'am.
All right. Can I have her relative come up?
Yeah.
Get out.
Hello. Hi. Can you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Janetta Henderson.
All right, and so are you related to Miss Turner?
Yes, ma'am.
And how are you related to her?
That's my mother.
All right. So do you have any children in your home?
Yes, ma'am.
And what are their ages?
16, 13, 12, and 10, and then my sister.
Oh, and your sister? Okay. And she's 19?
Yes.
So who all would be living in the home? It's your children, your sister, you, and then your mother?
Mm.
And are you okay with your mother living with you?
Yes, ma'am.
All right. So in this court, when I give people conditions of probation, everybody has different conditions. I don't have a cookie cutter set thing where everybody does this and everybody does that. I try to do conditions that can help the specific person that's before me. So what do you think your mom needs to help her to be successful on probation? Trick question, not a trick question. What kind of conditions can I give her to help her? For example, some people up here before me, they have children, so I know they need parenting classes.
Mm.
Some people have anger management problems, so I know that they may need some help with their anger management. What does she need, do you think? Oh, yeah, just tell me.
I'm sorry.
No, that's okay.
The drug court.
Okay,
Okay.
all right. Thank you so much for letting me know. And that's the type of honesty I need, because guess what? I always tell people when they appear before me, if you tell me you don't have a drug problem and I send you out into the world
Mm.
and you end up using, that's 100% on you.
Mm.
But if you tell me you have a drug problem and I send you on out in the world without giving you any help, then that's sort of on me, because you've said, Judge, help me. I have a drug problem. So I'm glad you let me know that. So I'm going to give her some treatment for that to make sure that that's not an issue, or at least she can recognize what an issue is and then take care of it. Because the last thing you need is somebody who may be using ended up over your children, because then that means that Child Protective Services is going to get involved. You understand? All right. So drug court, anything else? All right. Thank you so much for letting me know. I appreciate it. And thank you for coming back to support her.
Yes, ma'am.
All right. Thank you. All righty. If you'll come back. All right. So I want you to know, one, not your daughter's fault, right?
No.
Your daughter loves you.
Yes.
She wants you to be successful. I'm sure she doesn't want her mom to end up going to prison for 2 years, because then that'll be 2 years that she won't see you.
Yeah.
So I'm going to set conditions for you. And these are going to be conditions that can help you. I know that probation, I know that drug court, they're sort of full. So I'm going to try her with Esperanza Court. And Esperanza Court, they'll be able to see you this week or either next week at the latest. And if they don't see you next week, your attorney can come back and I'll see you next week, okay? And I want you to be 100% honest with them. And they're going to try to get you into a situation where you can be successful on this probation, okay?
Yes.
So there's going to be $1,000 fine. I'm going to probate that. There's going to be a referral to Esperanza Court. And that will be in custody. And if they haven't, counsel, if they haven't seen her by Wednesday of next week, just come back and let me know and we'll have it brought over and I'll take care of it, okay?
Yes, ma'am.
Sure, my client will remind me.
Okay. There's to be regular reporting by Zoom or in person. There's to be regular random UAs. There's to be proof of employment within 45 days of release. There's to be no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors. With regard to that no unsupervised contact, that means that there needs to be another adult who's suitable, you know, to be around the children. Once you are in complete sobriety, all your attorney has to do is come back to me and say, hey, we would like to change that, and I'll consider changing that. But for now, if you want to be around your grandchildren, there needs to be an adult there to say it's okay.
Yes, ma'am.
All right. There's going to be field visits 1 time per month until further notice. 150 hours community service restitution. How far did you go in school?
That,
All right. So what do you want to do with the rest of your life? If you could have your dream job, what would it be? No, you can. What do you want to do? When you were a little girl, who did you want to be? What did you want to grow up to be?
pediatric nurse in Houston.
All right. So let me explain something to you. You look at your life and you know what you say? I can never accomplish that, right? There was a guy, because I always go to the drug court graduations. There was a guy there who had all of these criminal cases, but he always wanted to be an attorney. And people will tell you, when you have criminal cases in your background, anything that you need a license for, the government does a background check. And when they see this criminal history, they'll say no. But guess what? He's an attorney. And you know what ended up happening? He graduated, he went to law school, and in law school, he let them know prior to going to law school, this is how I've changed my life. And they actually had a board to meet with him, a board of individuals to say, hey, why should we give you this license? He passed the bar and everything. And then he told them how he became addicted to drugs, how he changed his life around. And you know what he said they told him? Thank you for letting us know. We think you'll be good for the profession. So it's not something that's impossible. You just made it difficult.
Yeah.
All right. So I'm going to do 150 hours community service restitution. And if you obtain your GED, or if you get some sort of, go to some sort of trade school and get your certificate, I'll consider the 150 hours of community service restitution satisfied. All right.
Yes.
And we'll do referral to Center for Healthcare Services. And if not accepted into Esperanza Court, we'll follow TAP recommendations. And that's from the February TAP.
Thank you, Judge. I do want to point out, Judge, that Ms. Adams was on the MIG caseload.
Okay,
I would like to request from the court, mental health evaluation
okay.
out of custody if it's gonna, take a while.
All right, well,
So that we can make sure that she is still being supported that way.
all right, so we'll do MIC evaluation out of custody. Is there anything else?
I don't believe so, Judge.
All right. Is there anything else you need from the court to be successful?
No,
All right. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney?
yes, ma'am.
Did you understand it and sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. I know this seems like a lot, right? And you probably thought, I'm getting out of jail today. And so not getting out of jail today probably has hit you like a ton of bricks. But this is what you have to realize. In life, it takes time to be where you want to be, and it takes a lot of work. So the question you have to ask yourself, would you rather go to Esperanza Court and probably have 100%, well, 99% chance of completing this successfully, or not go to Esperanza Court and probably have a 10% chance of completing this successfully? This is something that you need. And once you get your life together and you do everything right, I'm sure your grandchildren will be happy to have their grandmother in their life, and your children, right?
Yes, ma'am.
So in this court, communication is key. If there's an issue, let your probation officer know. Even if you think you're going to use again, let your probation officer know. If they're not addressing it, you can always come back to the court. I'm always here Monday through Friday. Okay. All right. Good luck to you. Okay. I'm rooting for you.
Thank you.
All right.
There you go. Thank you.
Thank you. Have a good one. Are you all ready on Salinas?
Yes, Judge.
All right, we're back on the record in 2022 CR 2397. And the interpreter is present, but could I have parties re-announced for the record? State,
Andrew Harris Edelman.
defense?
Stephanie Collins.
All right, so first things first. Mr. Salinas? Did you receive the offer from the state?
See,
Yes. All right, did you understand the offer?
see,
Yes. All right, so knowing what the state's offer is, were you able to reach an agreement with them or no?
no,
All right, are you asking for a jury trial?
see,
Yes. All right. And state, did you want to place the offer on the record?
Yes, Your Honor.
Yes. All right, and then we have pretrial motions.
We do, Judge.
All right, the first one, I don't understand the issues you all have been having with the clothing exchange. Because my understanding with the clothing exchange here in Bear County, unless it has changed recently, what needs to happen is if the attorney is not the one who's bringing the clothing, if it's going to be a relative, then there needs to be a letter attached to it so that the jail will know that this relative is bringing clothing and when his jury trial is. So has that been solved?
Yes, Judge.
Okay.
We figured that out. I think there was just a misunderstanding of what exactly the judge or the jail wanted. Because I think Carlos's understanding was they were asking for an order, but I think we got that worked out with the help of another defense attorney.
Okay, awesome.
Great.
All right, then the next thing is him appearing in personal clothing and without restraints. What I can tell you, the deputies are in charge of security. They don't bring anybody over in handcuffs for the jury, but he will have on a leg brace.
Okay.
So is there an issue with the leg brace?
Judge, from what I understand, and the deputies can clarify if I'm incorrect, the leg brace cannot be seen under pants. And so as long as it cannot be seen and it's not visible, then we have no problem with that.
Well, I mean, they have the leg brace in the back, and what I can tell you is the leg braces are not seen when someone's wearing pants.
Perfect.
All right. Now, the next thing is all right, is there another motion besides that motion? Let me see, just one moment. Here we are. All right, motion to voir dire expert witnesses. All you have to do is request that whenever the state is going to call an expert witness. This is a aggravated assault with a deadly weapon. State, are you calling any expert witnesses or?
As far as I'm aware, Your Honor, no, we are not.
All right. Well, if you intend to call an expert witness, just let the court know and you can voir dire the witness outside the presence of the jury.
Thanks, Judge.
And then we have a motion in limine. What I can tell you is with regards to motion in limine, you can always approach on these.
Okay.
Many times I don't know the facts of the case until I know the facts of the case. So if there's an issue with priors, if the state is seeking to introduce 404B, state just approach before you get into anything of that nature.
Yes, Your Honor, and I apologize for interrupting, but there is additional information that I would like to add.
Yes.
ADA Escobar filed a notice of state's witness list, and on that witness list, ADA Escobar listed the following as expert witnesses. Officer M. Prado, CSI Kimberly Wong, Detective James Hankinson, and Detective Daniel Caraco, all of SAPD. I do not know what, if any, domain their expertise would be in, Your Honor.
All right, then you'll have to lay the foundation if they're being offered as expert witness. And then what subject matter are they an expert in? And then I'll excuse the jury. And then if you have questions for them that pertains to their expertise, then we will have a hearing on that outside the presence of the jury.
Thank you, Judge.
Understood, Your Honor. Thank you.
Right. And I'm reading through your motion in limine. All right, some of these motion in limines, I believe that this would just require an objection at the time. For example, if you think that the state during voir dire is committing a juror to specific facts of the case, then you'll need to object and the court will make a ruling on that.
Understood, Judge.
Reputation or character, state approach on that.
Yes, Your Honor.
Specific instances of conduct that are outside the presence of this case. For example, if the specific instance of conduct you are speaking of is conduct that relates to the aggravated assault with a deadly weapon, then that comes in. But if you're speaking to specific instances of conduct that are unrelated to the aggravated assault with a deadly weapon, then you all need to approach before you go into that.
So, Your Honor, if there is an extraneous offense that arises out of the same criminal episode for which the defense already has notice, we do not need to ask the court's permission to ask questions to witnesses about that.
Well, it is hard for me to know whether that's appropriate or not without hearing the facts. Just approach and I'll make a ruling on it. But it appears to the court that if there are facts in this case where there is one continuance alleged offense, that would be admissible.
Okay, Judge.
But from what I'm reading in your motion in limine, it appears that you may be asking for something unrelated to the facts of this case. Is that correct?
Correct, Judge. If there are, I would also ask that if there are extraneous offenses that occurred at the same time, but were unrelated to the ongoing episode as charged. I can't think of an example of these facts, but I could think of some random example, like a theft of a car and that has nothing really to do with the aggravated assault, if like something like that, even though it occurred sort of simultaneously. We would ask the state to approach on something like that.
All right, state just approach.
Understood, Your Honor.
All right, and then audio recordings of any witness for the defendant for impeachment purposes. All right, if it's an audio recording of your client, then you'll have to make whatever objections you deem appropriate at that time, and I will hear those objections. All right, and was there any type of offers or negotiations to pay medical and similar expenses and liability insurance in this case?
None that I'm aware of, Your Honor.
All right, if there is, approach before you bring that up. And remedial measures after.
Judge, I would say something like, offer to pay, an apology, anything like that. I don't think that there was that as far as I know, but if the state, is going to elicit that from a witness, or if they anticipate a witness saying that based on, anything they know now or anything they find out, then I would ask them to approach on that.
All right. So state, if there were any statements made by Mr. Salinas, have you already turned those statements over to the defense?
To the best of my knowledge, yes, Your Honor.
All right. So if you believe that there's something that a witness is going to say, a statement that your client has made that you're unaware of, then just object. We'll approach and I'll have a hearing outside the presence of the jury.
Thank you, Judge.
And we've already addressed the expert witness testimony. All right, let me ask you this. With regards to defense's motion in limine, did you all have a chance to review the defense's motion in limine?
Yes, Your Honor.
All right, is there any of this that you all have agreed on?
Judge,
Don't believe we conferred on any of it, Your Honor.
I did confer with Mr. Escobar, I believe, and I don't think we had any, did the state have any objections?
Judge, I think we specifically talked about a couple points on the motion limiting. I don't think we talked about all of it.
Okay.
All right, so let's do this. Number 15, state, you're not allowed to define reasonable doubt because there's no objection. I mean, there's no definition for reasonable doubt. So that will be granted.
Thank you.
Speaking objections. Here's the thing, I don't allow speaking objections, but if you believe somebody is making a speaking objection, object to
Okay.
speaking objection. Number 13, approach. Number 12, would you like to explain number 12 to the court?
Judge, I don't have
It's-
it in front of me, but
Any evidence, testimony, inquiry, or reference, either directly or indirectly relating to any argument, statement, or reference in the jury's presence by the state, comparing the facts, evidence, procedural circumstances, or competence of investigation of the instant case with any other legal proceedings in cases unrelated to this cause, or eliciting jurors' feelings, reactions, or opinion about such.
I think it's more appropriate and to limit that to the actual case in chief, as like arguments in opening statement or arguments in closing statement about, you know, think of the OJ case or think of, you know, the Johnny Depp case, like think of like how that happened and compare it to, you know, something they heard here.
All right, State, are you intending to compare this case to some other case?
Not in the way that defense counsel describes. However, there are aspects of the response by SAPD in this case that may be compared to other general responses in other cases.
All right, just approach.
Okay.
Expert testimony,
We'll-
yes. Approach,
And ask the court to
excuse the jury if,
excuse the jury and assert its gatekeeping function before allowing any expert testimony from any deemed expert witnesses, Your Honor.
yes. Number 10, approach. Number 9, they're saying there isn't any,
Okay.
but approach.
And
If there
Your
is-
Honor, if we learn of any between now and and when the proceedings actually commence, we will inform defense counsel as quickly as we can.
All right. All right, with, as far as audio recordings, any attempt by the state to introduce audio recordings of any witness for the defendant for impeachment purposes or for any other purpose without proper, oh, you're asking that the records be authenticated?
Yes, Judge.
All right, state number 8, you'll have to lay the foundation.
Understood, Your Honor.
So I think though that's, you know, you object to it if you deem they didn't lay the foundation.
Of course, Judge.
And we've already addressed 7, we've addressed 6. We've addressed 5. 4, you'll need to object. That's commitment questions to the jurors. Number 3 is also commitment question. You'll need to object. All right. Now, defendants' requests for notice. They want 404B. Is there any 404B?
I believe you've turned it over to us, is that correct?
Sure hope we have.
All right. And then the next thing is discovery.
Right, Judge. And I do believe the state has proffered that they've given us everything that they have in their possession. If they have not, I would ask that they do that before the trial commences. And if they have anything that they find during the course of the trial, that they turn that over to us, regardless of what it is and what they've deemed the significance of it is.
Yes.
Yes, Your Honor. And as far as I'm aware, there are no other crimes, wrongs, or acts or prior convictions which the state will seek to introduce that arise out of an offense that arises outside of this instant offense.
Okay. All right. And then with regards to discovery, if there's something that you discover during trial that you were entitled to and the state has not given you, then make the appropriate objections. And then I will make a ruling on whether or not it's admissible or not, or if there's a mistrial or whatever else is needed to remedy that situation.
Okay, thank you.
All right. Is there anything else?
No, to the preliminary issue that I wanted the court to address, I have confirmed with my client, and without revealing any privileged information, I do believe we've clarified that.
Okay. All right. All right. So then what will end up happening, they have to qualify the juries tomorrow.
Okay.
And that usually takes some time.
Sure.
So we'll start with voir dire. I'm going to say everyone be here at 9:30, but the jury will probably be up here at 10.
Okay. And Judge, do you all do jury questionnaires in Bear County? No?
Not for this level of felony.
Okay,
Yes.
okay. So is there a list or anything?
Yes, you'll get a list tomorrow.
Okay,
And of course, it'll be the standard juror card that's been filled out for them. But as far as jury questionnaires, that's not done on this level felony.
okay, Okay, I understand. Judge.
unless requested.
Okay, all right.
Okay.
Thank you, Judge.
You're welcome. Is there anything else?
I don't believe so. We did file our election of punishment. He does want to go to the jury. And then we will file a sworn a motion requesting probation or application for probation as well.
All right. Oh,
Before
you
the
can,
jury is called.
oh, you all can do that now.
Okay.
Yes. And
Do you have a favorite one?
yes.
Oh, okay.
All right. Is there anything else?
I don't believe so, Judge. Oh, how does the court wish us to address Anthony Wilson being an attorney of record? Because he is no longer with our firm. He is not respondent to any communications from our firm except to provide his resignation.
Well,
And so,
that's, I mean, the jury is not going to know that
Okay.
Anthony Wilson was previously at your firm or was an attorney unless y'all
course.
want to tell the jurors that.
I just, for the purposes of the record, I don't know if the court had any concern about him continuing to be listed, but
No, I mean, because the person they have listed now is Carlos Ramirez.
okay, great. All right. Thank you, Judge.
All right, you're welcome.
Are we excused, Your Honor?
State your excuse, but she still needs you for a moment so they can have him fill out the fill out his election for punishment and also swear on the never been convicted of a felony before.
Thank you, Your Honor.
All right, thank you.
So is the trial starting tomorrow, Judge?
Yes. And so we'll start with jury selection.
They can
I'm
call
not sure
for
the jury will probably be up here at 9:45. We probably won't be able to start before 10.
Okay, they can call and see.
Okay.
All right.
All
Okay,
right,
let
thank
them
you
know.
so much.
So he actually needs to sign this.
Tiene que firmar eso.
So basically.